Well, good evening, ladies and gentlemen. I hate being late, but it's 6 according to me, but we are still short of one councillor. But I want to get on, so possibly I'm hoping that he hasn't gone to Weeley for his meeting, but we shall see. My name's Councillor White, John White. I'm chairman this evening. On my left, I have my vice chairman, Councillor McWilliams. The other councillors sitting on the two side tables, these are the ones who will debate and ultimately vote on the applications in front of us tonight. On my immediate left and right, I have TDC officers, including the head of planning and the council's senior solicitor. This is a formal committee, and it's very important that councillors can hear and debate all of the presentations. So I do request that you remain quiet and not interrupt the speakers. The order of business tonight will be exactly the same. I know some of you have been to our previous meetings. We will start with an officer presentation. We will then go into public speaking, that's both for and against. Then the parish or town councillor, in this case parish councillor, will speak. Then the ward councillor, and finally the applicant. Any further comment can be made at that point from the officer to correct anything that might have been said. The committee will then ask questions, and then once they've done that, they will debate and finally vote on the application. I should finally add that this meeting is being recorded by the council and will be available on the council website in approximately 7 to 10 days' time. So if we can go to the agenda. I can't see whether some of you have right. The council has just arrived in time, so that's good. Item 1 on the agenda is apologies and any substitutions. So, yes.
Chairman, we've got apologies from Councillors Harris, Bray and Placey, and their substitutes are Stevenson, Val Guglielmi and Paul Clifton.
Thank you very much. Item 2, any declarations of interest, that's any disclosable pecuniary interest or any personal interest, and what the nature of that will be. So I look around the councillors to see. Yes, I have one. Yes.
Yeah, sorry for being late, Mr. Chairman. I am councillor of Kirby Cross Ward, which is coming up later on the agenda, but as I didn't attend the site visit, I don't think I can vote on it anyway.
Right, thank you. That is the second application on the agenda. And Councillor Val Guglielmi?
Yes, I have a personal interest in the fact that I'm on the Lawford Housing Trust with Stephen Rose. Not Rose Builders, Stephen Rose. So I have no pecuniary interest. Okay.
Thank you very much. No others? Right. In that case, it turns us to the main application in front of us tonight, and that is planning application 1900524. This is purely an outline planning permission that's being sought. It's land to the south of Thorpe Road, Weeley, and turn to the officer to introduce it to us.
Thank you, Chairman. The item before us tonight, as is said, is for land south of Thorpe Road in Weeley. It's an application for up to 280 dwellings, a 2-form entry primary school with 56 place early years nursery, 3,000 square metres of office space on 1 hectare of land with associated ancillary facilities, drainage systems, boundary treatments, hard surfacing, public open space. Vehicular access will be from Thorpe Road. and there will be a pedestrian footbridge over the existing railway line, and that will actually lead to the closure of the existing level crossing. And as part of that, there will be a need for a diversion of footpath number 5. The plan before you shows the site in red. As you can see, it's the land between Thorpe Road and going down to the railway. There is a small section of land to the south side of the railway which is included in the application, and that is to help facilitate the delivery of the footpath pedestrian crossing over the railway line. There's an aerial picture of the same. Obviously the site is on the eastern side of Weeley. As we're aware, it's an emerging allocation in the emerging local plan, essentially for the same quantum of development up to or a minimum of 280 dwellings, and for the delivery of the various other facilities which are part of this application, which includes a primary school, employment, and, as I said earlier, delivery of a footpath crossing over the railway line. Taking you in terms of views of the site, this is a view from Thorpe Road. This is the entrance into what will be the new development. This was a development from a while back for delivery of Barleyfields Drive, and to the back of that screen will be the land in question. This is at the very end of that existing cul-de-sac, and obviously there will be a continuation of the development into the land to the south. Just a view of the northern field. Again, another view of the northern field. That view is looking more towards the southeast of the site. There's obviously hedgerow boundaries that demarcate most of the outer boundaries of this particular site. This is looking at the back of the residential scheme, Barleyfields again, looking to that the top end of the site. This is more in the centre of the site. This is actually the footpath that leads down from Thorpe Road and goes past the eastern side of our particular site, and there is obviously a horticultural use on the eastern side of that as well, which we'll go on to a bit later. Again, showing the various hedgerows that surround the particular site. This is adjacent and west of footpath number 3 that crosses the site. This is more to the centre of the site, showing the existing hedgerows and looking back towards Barleyfields again, which is the northern part of the site. Further views looking across the site, looking southwest to the corner of the site, and you can just about see the new development at St Andrews Road in the foreground. This is moving now to the very rear of the site. This is an existing copse of trees. There's a footpath that runs through it at the moment, and that leads to the level crossing across the railway line. And this is the existing level crossing, which, as we'll see in the plans further on, will actually be stopped up, and there'll be a new railway crossing in terms of a pedestrian bridge. This is a view looking southwest to the southwest corner of the site towards new development at St Andrews Road in the foreground. This is a photo from the street, from the junction with Colchester Road and Thorpe Road. This is the frontage of Thorpe Road, looking eastwards towards the junction with the streets. This is Ash's Farmhouse that sits on the frontage of the site. It's a Grade 2 listed building and doesn't form part of this planning application, will be retained in situ, as will some of its curtilage buildings to the rear of the site, which is a slight change from the previous application. They were included, the curtilage buildings. In this particular regard, that has now been removed from this particular application. That's a view into the outbuildings from that particular site. As I said, the nearest ones are now not included in the application, whereas the rear ones will be removed to make way for employment uses. This particular plan is showing the existing footpath network across the site. there's a number of networks, one that runs north-south from Thorpe Road and leads down to the railway line and across at the existing level crossing. And there's also one that kind of runs in an east-westerly direction from Thorpe and links up with the other footpath network. This is showing in more detail the footpath and distribution of uses on the site and how that will work in terms of linkages. Obviously, you have Thorpe Road to the north, Crow Lane to the north of that. We'll talk about the junction improvements that will happen there in that regard. We'll go on to other plans. It's just potentially showing potential linkages through the site and how that will actually work. The blue area on that plan is employment area, just to south of Ashes Farm listed buildings. And the more purple area is where the new primary school will be situated on the site. This plan shows the proposed new footpath crossing over the railway line. It does differ from the original scheme from a year ago, which was a more traditional crossing with footsteps up it. This particular version obviously takes on board disabled access and is obviously ramped to allow and facilitate access for all users of this particular bridge. This shows particular different junctions that will actually improved and various changes across the network, particularly across Thorpe Road. There will be various measures in terms of things like new gateway entrances to the scheme. With regard to Crow Lane, which sits opposite the site, there will be improvements to that particular junction, a closing off of a lay-by and various other improvements. There will be a right-hand turn lane into that junction as well. This particular plan shows how the footpath network will deviate. The one deviation from the current situation on the site is with regard to where the new footpath railway bridge will be positioned. To facilitate the closure of the existing footpath network across the railway line, that will be shut, and there will be the new bridge, which will be located just slightly to the east of that. So to actually facilitate that, there will be a need for a slight diversion of the footpath network as well. And that is essentially the scheme before you. In terms of financial contributions that will be delivered as part of the application, there is a suite of measures that will be incorporated in the scheme. It is a package for circa just over 3 million, which will be delivered from this scheme. Principally, that will be for education. There will be, as I said, 2.1 hectares of land to accommodate a new primary school on the site, which will be transferred to the county council. But in addition to that, there will be a need for financial contributions for primary, secondary school education and transport links to the secondary school, which is more than 3 miles from this particular site. In terms of healthcare, there is a contribution of just under 100,000, and that will actually be to deliver a relocation of the Thorpe surgery, or a potential other option for that is to improve the existing facilities at that particular surgery and also the other feeder surgery serving Weeley at Great Bentley. In terms of ecology, Weeley Wood, Triple SI, lies to the north of the site, and Essex Wildlife Trusts are concerned about potential additional activity and recreational uses within that woodland. And what has been negotiated and agreed with them is a financial contribution of 55,000 towards improvements to the footpath network through that woodland, which will actually make that more formalised and endeavour to remove movements more informally within that woodland area, and they are happy with that. In terms of more national ecology, in terms of habitats and impacts on the various coastal recreational zones and areas of conservation, what has been agreed as part of what's the recreational management scheme is a sum of 34,000, which is a contribution per unit. And that is actually used for is to mitigate against uses of various coastal habitats. which could be for wardens and various ways of keeping them on formal pathways. In terms of highways and transportation, the Section 1 of 6 requires upgrades of the Weeley roundabout by the service station and the McDonald's, and also further down at the next roundabout at Freighting. And that actually comes to a sum of circa 150,000 towards that. As I said previously, there are other upgrades as part of the localised network in terms of upgrades of junctions and various other traffic calming measures on Thorpe Road. In terms of the public rights of way, as I said previously, there will be a need, well, firstly for the delivery of the railway bridge, and what has been agreed and negotiated with the applicant and following comments from Network Rail is no more than 25 dwellings on the site can be occupied before the delivery of the railway bridge, and also the diversion of the footpath which will facilitate that particular access. On top of the other elements I've suggested, there will be public open space provided on the site, and as part of that there will be various other mitigation in terms of ecology as part of that. And that's all I have to say at this point, Chairman.
Thank you very much. And now we get to the public speaking part of the application. And I call Mr. Derek Stebbing. Welcome, Mr. Stebbing. Take your seat, and once you're settled and got your microphone live.
3 minutes.
You have indeed.
Thank you, Chairman. I hope everybody can hear me. Councillors, my name is Derek Stebbing, and thank you for allowing me to address you this evening. I'm speaking tonight not just from my own perspective, but also on behalf of the many, and you see them behind me, Weeley residents. My comments are also their comments. We are here tonight because of decisions that were taken by your committee in confidential session on March the 12th this year, after we were all asked to leave that meeting. Nobody from the council, either officers or councillors, has since sought to offer any explanation or clarification to Weeley residents regarding the decisions that you took in confidential session that evening. We were left in the dark. That is quite disgraceful in the 21st century, when there should be transparency on decisions made by public bodies, particularly when those decisions affect the place and places where people live. But from tonight's agenda, it has of course become clear what was decided that night. Such was the haste to submit this new application, which was submitted within days of March the 12th, that some key surveys that should have been updated in accordance with best practice, national practice, since they were last prepared in 2017, have not been updated. But nobody seems concerned about that. I give you one important example, the Bat Activity Survey. And this site, at dusk on an evening such as this, will be full of bats. That dates from 2017. It should now be updated in accordance with national guidance with summer 2019 data to enable you to determine this application. And why is that important? Because all bats are nationally protected species, all bats. And the site is a key habitat for bats, particularly in the wooded area closer to the railway. And what is the biggest threat to that habitat? The proposed railway footbridge. And that brings me to my next point. Your officer has shown you the design of that footbridge. In my assessment, and in the assessment of many other people, the design of that footbridge is horrendous. At a tranquil spot some 200 metres from Weeley Church. That footbridge will be floodlit all night, screened by steel palisade fencing stretching either side of it. And as your green sheet notes, whilst this application doesn't include any floodlighting or steel palisade fencing, They are Network Rail requirements for a footbridge of that sort, and Network Rail will insist on it to prevent shortcuts. That footbridge also results, during the construction of it, in the loss and destruction of significant areas of woodland and wildlife habitat. My words, this is planning vandalism. So why is that of concern? Because the impact of that bridge, which has been completely redesigned from a much earlier and smaller footbridge, is now a hugely bigger structure. It's bigger than many structures over the motorways in this country. That new huge structure has not been assessed fully in terms of its impact on woodland and wildlife habitats, and certainly not in terms of its impact upon the bat population. Councillors, I'm sorry to say, but this council's handling of this planning application has been shoddy. Residents have been kept in the dark since March the 12th. At least one neighbouring property has not been consulted at all on this application, or the previous application, or the appeal that lies between those. Some of your key data you're relying on this evening is out of date. I say to you that the right place to determine whether these proposals are right for Weeley is at the ongoing local plan examination. Many of us have made representations to that examination, and the independent inspector is considering it. It is not our fault, it's not your fault, that this examination is now going to extend over 3 years. But why should Weeley be made to suffer the consequences of that delay? If you approve this application tonight, you will be depriving, once and for all, of the Weeley community having any say whatsoever about the future of their village. And this proposal adds 60% to the built area of the village. And that is because tonight you have decided not to await the outcome of the local plan examination. You are effectively usurping the decisions of that inspector, whatever they might be next year. And you are also now capitulating on the ongoing planning appeal. At the very least, I consider you should defer determination of this application tonight. Thank you very much for allowing me to speak.
Right, colleagues, thank you for that. Now I want the parish councillor, Councillor Mike Brown. Welcome, Councillor Brown. You're well aware of the procedure, so I won't elaborate.
Good evening, councillors. Before I start, I wish to state that I don't think 3 minutes is anywhere near enough to cover all that is relevant to this contentious development that Weeley is threatened with. Councillors, I'm going to concentrate on matters others will not cover in detail. I'm going to explore sustainability. In the Barley Fields area, doctors are under stress in the area. 3 weeks to get an appointment is common. Education. Some parents have to transport their children out of the village as local schools are full. I know you hear this on occasions, on other plans. However, it remains very relevant to Weeley residents. It has been stated that doctors are to be relocated to Barley Fields area, but both surgeries suggested state categorically they're not moving. Please note, the more experienced of you on the planning committee will have had plans before them where developers promised to build a school or medical centre. How often do we hear of one being built and operative? The reason is it's up to the NHS and Education Authority to finance them. Travel infrastructure. Councillors, how many of you use the roads in Weeley, especially during commuting times? Well, the roads are clogged. So much so, the road through Weeley Heath is now an early morning rat run, as it gives priority to the roundabout at the end of the bypass. Apparently, councillors, Weeley is a transport hub. Well, I beg to differ. I have covered roads, now the railways. Only 2 trains to London in the morning with no chance of more, as Liverpool Street is at capacity. Weeley's Parish Council did their own survey and found only between 6 and 8 people use it to commute per train. The station itself is a disgrace. Disabled or pram users cannot get access on the easterly direction platform. They have to go to Clacton first. The main station building is derelict and the whole area is poorly lit. I would not let a daughter of mine go unescorted after dark. There is no car park as the rail company has sold it to what looks like a car salvage yard, so it would appear there's little ambition to change. Councillors, the next village up the line, Bentley, has recently had a development of 75 houses refused because of serious detrimental damage. A very similar situation to Weeley. So why should Weeley be chosen for 280 dwellings when we've already had our fair share in the area? Councillors, I trust you have read all the letters of objections which have been submitted on this and previous application, as the development is the most contentious ever experienced in Weeley, and Weeley is probably on the cusp of becoming a town. Please be aware, especially new committee members, the strength of feeling against this deeply unpopular, unsustainable application, a virtual carbon copy of the previous application currently sitting at the appeal stage. Residents can't understand the pressure to push this development and feel there is financial blackmail because of strong threats of damages if not granted. Councillors, if we concede to the deep pockets of Rose builders, Weeley in all but name ceased to be a village. The local area has already suffered disproportionate building. This area of Weeley is the very best part for recreation and well-being, and when it's gone, it's gone. Thank you.
Thank you, Mark. Right, now the ward councillor, Councillor Peter Harris, who I know appreciates that he actually gets 5 minutes.
There we go. Before I start, excuse me, I'd just like to thank all the residents that sit here behind me today, and thank you for coming out and showing their support in their objections to this. It's appreciated very much, and obviously I think it will show the committee the strength of feeling. I'm sure there are many, many more hundreds of people that would have liked to have attended tonight. So, Mr. Chairman and committee, I have spoken with hundreds of residents about this development. None have been in favour. Many objections have been submitted. I know that this committee will challenge officers on the application that comes before it. It's what it does well. But this is not just another application. Your decision could change this historic village of Weeley, its very character, and the lives of people that live there forever. I ask you, what price can you put on that? The elephant in the room is the legal advice given to TDC on the previous application. Most lawyers' opinions vary in some way. That's why we have judges, or in this case, a government planning inspector. Yet TDC have taken the viewpoint from just one lawyer and decided not to give evidence based on defending other applications not connected to Weeley. This lets down Weeley residents and is not right. Instead, a deal has been agreed between TDC and the developer, which puts huge pressure on this committee tonight. Do you go along with this deal, or do you turn it down because it is wrong? It was wrong in November when it was refused, and it is still wrong. This is still overdevelopment, and it is still premature. And it should be noted, there is no legal certainty whatsoever that costs will be awarded at all. It is down to the applicant to prove unreasonable behaviour by TDC and therefore this committee. I don't think you have acted unreasonably, do you? Therefore, there should be no costs awarded. I now turn to last Tuesday when we all sat here and voted to accept stage 1 of the local plan, the garden community proposal. It will now go before the inspector in January, just 5 months away. If approved, the number of houses needed in tendering will be 550 per year. Why is this figure important? It's important because, as confirmed by Councillor Nick Turner, Chairman of the Local Plan Committee, we are already significantly ahead of our target of 11,000 and now only need less than 1,200 up until the year 2033. That's just 85 a year. So in terms of numbers, these 280 houses are not crucial in the scheme of things. Add to this the residents' pending objections to Section 2, which deserves to be heard. We have already heard that there has been a significant change to the original plans. And I'm talking about the hideous, ugly, giant, zigzagging metal railway bridge, which will stand there glowing every night in the countryside, like a cross between Spaghetti Junction and the Eiffel Tower. It's massive, and it will have a devastating effect on wildlife, but particularly the population. It is now in the direct flight path of bats. Yet the applicant's own report, dated very appropriately on the 1st of April, states in the habitat assessment the site remains generally of the same composition as it was when assessed in 2016. This is nonsense. Planning officers cannot rely on such reports but have a legal duty themselves to protect in the protection of bats. The Conservation Natural Habitats Regs 1994 defines European protected species and says it is an offence to deliberately disturb in a way that would significantly affect their local distribution or affect their ability to survive, breed or rear young or damage or destroy a bat roost. This is an absolute offence. Furthermore, it is an offence under the Wildlife and Countryside Act 1981 to intentionally or recklessly disturb a bat roost or obstruct access to a roost. I refer to the High Court case of Weeley versus Cheshire East Borough Council. It clarified the legal duty of the planning authority when determining an application for the development which may have an impact on European protected species, which all bats are. It said where applications are determined by a planning committee, the planning officer has a key role in identifying the relevant legal duty and should specifically highlight this duty in his report so that the planning committee can discharge it. In this case, the officer's report made no mention of either the directive or the regulations and merely noted the existence of bats and proposed conditions for the mitigation of the disturbance of bats. The court judged that this was considered to be a substantive breach of European law and was enough on its own to justify quashing of the planning permission. Members of the committee, you have not received sufficient information from TDC officers and therefore you must refuse this application. The NPPF and TDC policy states that a suitable and sustainable location for development must assess the environmental amenity impact experienced by the would-be occupiers and neighbouring areas. This application has completely failed to do so. Tendring Riding Club, a club formed 75 years ago and immediate neighbours to this site, has not been consulted. Currently set in a tranquil setting, the impact of this development will have serious health and safety consequences. Horses are flight animals and can spook at the slightest things. Construction noise will have a massive impact and will almost certainly result in rider accidents. Noise from gardens in close proximity will have similar effect. Sustainability and viability of this important amenity and established business would be threatened as customers simply turn away. We have already lost other venues and we cannot allow this to happen. I therefore urge this committee to reject this application. Thank you.
Thank you, Councillor Harris. I now call upon the applicant or agent to speak, and I'm not sure if anybody... I'm getting indications that they don't wish to speak. Is that correct? Looking towards...
No, they're not. They shook their head.
Right, OK, in that case, I'm coming back to Mr Faulkner to see if he's got anything that he wishes to challenge or agree with before we start the debate.
Thank you, Chairman.
Is that mic still on? Yes. It is. Right, thank you.
Thank you, Chairman. Going through the various items that have been raised, with regard to the railway bridge crossing, I agree from the original application, yes, there has been a change in design, but clearly for accessibility reasons and to meet obviously modern standards in terms of people being able to access it with disabilities, clearly there is a design reason for that particular change in design. Yes, there is a railway bridge at, and I think that's been intimated, at the existing Weeley station, which is the old type of railway crossing, where it's a stepped access and does obviously stop disabled access from platform to platform. Clearly, in modern times, we should be designing to meet proper new standards. In terms of exciting, clearly land does fall away from north to south into where the railway line is actually positioned. There is a copse of trees immediately to the west of it, to the north side of the railway, that to a certain extent hides the proposed railway bridge from Weeley more generally. And there is various trees that line the railway line as well. I note the comments with regard to obviously the bats within that particular location, but clearly they are protected species, and obviously the ultimate design of the bridge will have to be designed to actually accommodate that. And clearly if there is a pressure or risk to bats, then a licence application would have to be submitted to deal with that. In terms of ecology more generally, as part of the new application, there was an updated report that was submitted with the application. The applicant's ecologists did revisit the site in advance of the submission of another report in April. In terms of the dates of surveys and when that should be done, in terms of guidance that comes out of the Chartered Institute of Ecology and Environmental Management, which is obviously the vice for that particular institution, surveys can be up to 3 years old and can still be assessed as part of that in terms of a professional ecologist's judgment on an application, and can still remain as valid. This is an outline application. The only thing that's actually being resolved today, if approved, is the access to the scheme. In terms of all other matters, in terms of the layout of the scheme and where everything will actually sit on the site, that will be subject to reserved matters application. So in terms of wider ecology, that can be dealt with as part of that application. Although I would say in terms of existing hedgerows on the site, the applicant has alluded to those being retained. And in terms of the copse of trees to the south of the site, again, that will be retained as part of this application. And there are various other measures that are recommended in the ecology report to mitigate against ecological impacts. One thing that was picked up was slow worms on the site, and as part of this application there will be translocation of slow worms to near the railway line to the south side of the site. Turning to some more wider issues in terms of sustainability. More was raised again in terms of education and healthcare and this development pushing things to the limit and beyond. Well, clearly the application does include land for a new primary school on the site, for preschool uses on there as well, and there will be full contributions for primary school places, secondary places, transport to the nearest secondary schools. In terms of healthcare, there is a contribution of just 100,000 that will be delivered as part of this application, either to upgrade existing surgeries or to relocate to a new facility, which could be in Weeley or could be somewhere else in the vicinity of the site. In terms of transportation issues and implications in terms of vehicular access, highway pressures. Clearly there is a significant number of measures that are proposed through this application in terms of traffic calming measures along Thorpe Road and contributions towards upgrades of the roundabout by the McDonald's and also the Fratting roundabout as part of this application. Moving slightly back to the ecology, clearly Natural England, the Environment Agency, the Essex Wildlife Trust have all been party to the application and made comments on the application. and clearly did not raise objections to the application as submitted. In terms of consultation on the application, clearly the council does do a wide letter drop in terms of immediate neighbours. Clearly it's not always possible to pick up on every neighbour, but clearly this application would also have been consulted by way of site notices around the site, and also by a press release in terms of putting the application within the press. So we have met our statutory duty in that regard, and clearly work in terms of both the site coming through the local plan process as an emerging allocation, the previous application and the application now before you. Clearly this has been in the public domain for some time, so it is somewhat surprising that people haven't picked up on the application within that time frame. It clearly has been in the public domain in various forms for some considerable time, as I said, including through the local plan process as well. In terms of the railway bridge, just turning back to the comments about lighting and palisade fencing, well, that isn't a known variable at this particular time. Again, in terms of habitat and wildlife protection, clearly any design, if there is a need for lighting across that bridge, can be designed in such a way to obviously take into consideration bats, certainly from experience of other schemes where there is protection of bats, and it's a key consideration in terms of the nighttime environment. There are measures that can be put in place in terms of the nighttime environment, in terms of how lighting works within the local environment. I think I've hopefully covered anything, but happy to divert to the Chair.
Thank you very much. Councillor Guglielmi, you declared a non-pecuniary interest.
Yes, I did, a personal and a non-pecuniary interest. Because I am on the Lawford Housing Trust with Mr Stephen Rose. Nothing to do with Rose Builders, but Stephen Rose as a person. We're both directors on the Housing Trust. Nothing to do with this at all.
Right. Thank you. Right. Now, councillors, down to you to talk. I look to you now to see who likes to start the ball rolling. No? Yes. Councillor Guglielmi.
I'd like to start it only in the fact that I was concerned that the people with the horses next door to the site hadn't been aware that this was happening. So I did go and speak to them across the field, and spoke to them, and to allay any fears that there weren't any horses actually on their events. They don't actually house any horses on the site. That had to put my mind at rest, because I have a family that are horse lovers anyway. But these are events, they come and go, they're not permanently on that site.
Thank you for that. Yes,
Clifton.
Councillor Clifton, thank you.
Yes, thank you. There were some very good points raised by members of the public and various councillors. I share your concerns about the bridge. It is a bit of a monstrosity. I will tonight be travelling back from work. I will travel along the A428 on a road diversion, and there is a monstrous bridge over the 428. It's big and it's blue and it's an absolute eyesore. So I do share concerns that a bridge of this sort of magnitude, appreciate it wouldn't be as big as the one that crosses the 428, but they are a bit of an eyesore. So I would ask that when this goes further down the planning process, if it should get that stage, that we do put a lot of pressure on Network Rail to put something that is very in keeping and friendly with the bat population.
Right. I think councillors I'm sure the officer will answer it, but one of the points that were raised by somebody else in their opposition compared it with the existing bridge at the railway station. And of course, since that was constructed, we have the Disability Act, which doesn't allow us to have steps straight up, because obviously people in wheelchairs and other things couldn't cope with that. So there's a laid down agreement, I believe I'm right in saying, because I was involved with it in a theatre, that it must not exceed a 1 in 20 ramp, which is the reason for this great long length. But the officer might comment on that.
Yes, speaking to the applicant, I think it's 1 in 16, but it's there or thereabouts. That's why the design is what it is, unfortunately. You do need ramps to be of a certain gradient to obviously facilitate disabled access.
And further to that, because I know it happened to me as well, the DDA doesn't like a ramp that's more than a certain number of yards without having brakes in it. Because if a wheelchair ran away, they could do 100 yards if it was a straight length. So they advise you to zigzag it, which does, as you say, it does look very, very big indeed. But as far as I could see, it would be needed if the bridge has got to be there. And I'm sure that's not going to come cheap. I'm sure that'll probably push £1 million to construct it. So, but there we go. Right, other points. Anybody? Councillor Stevenson.
Thank you, Chair. Fairly new to this committee, substituting for Peter Harris. Just talking about the bridge, can I just have some clarity from the officer? Is there a different design bridge that we can have? Can we have a step bridge? And who's insisting that we have the current bridge, please?
I'll just really reiterate what I say in terms of Network Rail obviously have to meet certain standards in terms. Clearly, the existing crossing is level, so whilst not ideal, yes, clearly disabled people can cross that. But in terms of a new design to meet accessibility standards, as we see in most walks of life now in any forms of development, we should be meeting the needs of that particular part of our community, and clearly that is the reason for this particular design. It's not uncommon. Yes, historically, if you look at Weeley Station, there is an old railway bridge that doesn't meet that standard, but it obviously doesn't mean that's right, and clearly, whilst it is a large structure, clearly there is a need to meet accessible needs of the population.
Right. Yes, Councillor Stevenson.
So, from that, there is no different design. We can't have a step bridge and it's Network Rail. Is that right?
In terms of the Section 106 agreement, it has to be delivered. The final design still needs to be negotiated with Network Rail and the applicant to actually deliver that. So it's the design before you isn't necessarily the final design of the scheme, and clearly can still be negotiated. But I do still suspect, in terms of the form of it, it will still have to deliver accessibility for disabled groups, and hence the reason for a ramped access. It's not just disabled groups. Obviously, parents with buggies as well would be disenfranchised by not having this form of ramped access, which is quite common across major roads. And the reason we're actually talking about this today is clearly Network Rail have identified this as an unsafe crossing of the railway line. It is national policy to close level crossings, pedestrian level crossings, and obviously Network Rail, as part of their response to the application, are quite clear this needs to be delivered. In fact, obviously they've strengthened their position during the life of the application. In terms of the local plan, it should have been, there was a delivery at 100 units on the site. That has now moved down to 25 units before the footpath is actually delivered. For safety reasons, they are quite clearly concerned that this bridge is needed to obviate any potential issues of safety here.
All right.
Coming back to both Mr Stebbings and Councillor Harris's comments about the back activity 2017 survey, can you just clarify, because I didn't quite get it from when you were summing up earlier, whether that's a problem or not, because some people seem to think it is and we don't seem to think it is. So,
there's various elements to this. As I said, we've taken advice on this. Clearly, surveys can be up to 3 years. That's not ideal, and clearly they should be done within a year, ideally. but we are talking of an outline application where only the means of access is actually looking to be agreed at this stage. In terms of the scheme, there clearly is scope to retain habitats in terms of the hedgerows and copse of trees and other buildings where bat activity has been identified, and they will be retained as part of this scheme. And as part of the multitude of planning conditions that are actually being imposed on the planning application, there are conditions that deal with ecology and will need to be addressed.
Sorry, Chairman, to keep on going on. Coming back to Mr. Stebbings' comments about the local plan and why can't we wait for part one? I believe this is called prematurity, something along those lines. And I was wondering I've come across it on page 23 and 6.29. I think that's what it's referring to. Could you confirm what prematurity is for me, please?
You quoted 6.29, right? Yes, I've got that.
Yes, Chair. In response to that particular question, this was a matter that was actually addressed through the previous application on this site, so I appreciate there's a change of membership here. And when the scheme was first brought before members, it was actually deferred at that time because the view was taken by members that potentially the application was premature in advance of the local plan and moving forward through the local plan process. At that point, it was deferred, and we received advice from the applicant's solicitor, and clearly they came back to say, in terms of national guidance, this particular application couldn't be seen as premature. And in terms of dealing with the application, the judgment was it should move forward it's prejudicial to the applicant's position in the sense it should be determined. Either it should be up for approval or members have the right to obviously turn down the application, but to actually hold it in abeyance and not make a decision at all cannot be seen as correct in this particular regard, and obviously legal advice was taken to come to that judgment.
Councillor Stevenson, still continuing?
If you don't mind. Just wanted to check the outline of the planning application itself. In the local plan, the emerging local plan, the boundary goes up to the edge of the railway. The one in front of us has a section across the railway. I assume this is the bridge. Could you confirm, please?
Yes, Chairman. In terms of the land to the south of the railway line, yes, that land is to facilitate the railway bridge across the railway. You're right, in terms of the emerging local plan, clearly it is just the piece of land to the north of the railway line. That is actually part of the allocation.
Yes. That's it. Right.
Morris.
Councillor Alexander.
Thank you, Chair. I'd like to go back to the beginning, basically, on page 2, at 1.5. I would like to ask Councillor Brown raise the issue of lack of schooling within the village, and that adult parents were taking their children some distance away because there was insufficient places there. Surely with the building of this and 56 places in early years, this will help to solve that problem. And also, I would like you to give us assurance on the rapid transport for how the older children would be getting to and fro from their designated schools, which I believe would be Tendring Tech and Landermere, or even as far away as Coastal Academy.
Yes.
Thank you, Chair. In response to that, in terms of the primary education, clearly as part of this particular application, there is land being offered for a new primary school on the site. So in terms of provision within the local community, there will be a new primary school actually provided to meet the needs of the local community and the new developments. Children that actually go to that school from outside of the area, and if they're more than 3 miles from the particular site, then clearly they can actually seek contributions or seek transportation. If they can't get into another school, then the county council are obviously obliged to find schooling for children, and if it happens to be this particular site and it's more than 3 miles from their home, then transportation would have to be provided. But in terms of secondary education, as part of the Section 106 agreement, there is, as you say, the secondary education is more than 3 miles from this particular site, or more than 3 miles walking distance. So there are financial contributions being provided as part of the Section 106 to deliver that.
Yes?
Right, now where are we? Jumping around a little bit, but staying firstly on page 2, 1.6. The site lies outside the settlement development boundary for Weeley. But then moving to page 5, I believe that there is a dispensation in place in which we have saved policies to the 2007, and now we're moving on to 1333. Under that the paragraph 48 of the MPPF also allows weight to be given to the policies in emerging plans according to their stage of preparation. Could you please explain that to me, please?
Yes, thank you, Chair. In response to that, yes, different weight is accorded to plans to where they are in the plan-making process. In this regard, we have an adopted local plan, which is obviously time expired, but policy within it, which obviously align with the National Planning Policy Framework, can still be given at least moderate weight in decision-making. In terms of the emerging tendering local plan, 2013 to 2033, clearly we consider that obviously can be given relative weight because it has gone through the formal process of being agreed for council to go in to the inspectorate for examination. And in that regard, we consider it should be given reasonable level of weight in the determination of planning applications, and that's very much in line with guidance in the National Planning Policy Framework.
Please.
We were handed this today, and it's in the green papers, and something caught my eye. We were talking about the bridge. First and foremost, I believe that we at tendering run a fully inclusive council and recognise the needs of all members of our society, whether they be able-bodied or not. Provision should be made for anyone who lives here. And they were the actual bridge, I know of a bridge of this sort. I've seen it in Kent and in Surrey. They are large, there's no two ways about it, but for what they stand for in the field of inclusion, they are second to none for what freedom it gives to people who would not enjoy that freedom before. And you are forgetting these electric-styled buggies. And they must have that turning point as well, for they are much larger than a standard wheelchair. So I'm not altogether anti this bridge. I'm given the choice. I'd like everyone to be perfect, and we didn't have to have it. But it's not what it is. And what it is that we do have members of our society who play a very active role and should be treated with the same as everybody else. And also it says here, I can't give you a piece on this, there isn't any. With respect to the railway bridge crossing, there is no indication within the proposal that it will either be lit or subject to associated fencing. Could you agree? Is that correct?
Thank you, Chair. I'd allude to my earlier response. Clearly, as it stands, the proposals do not include palisade fencing and lighting. But I do accept what Mr Stebbings is saying. Clearly, there are requirements that no doubt Network Rail will look to impose for safety reasons. But that's not known at this particular time and will be considered further on as those proposals move forward. And I'd reiterate the point I made earlier in terms of bats. Clearly, they are a protected species, and anything that impacts on them will obviously have to be fully licensed if there is a material impact on them.
Yes, please.
So let's talk about these bats. Did the survey identify possibly what species they might be?
Unfortunately, I don't have that particular detail in front of me at this precise moment. I know there was 3 types. I know pipistrelle was the most common one, and I think there was a couple of other examples that were actually referred to as well. But clearly there is still potential to have further survey work done. This application is just purely for outline with access to be agreed in terms of the detail. Clearly, anything that's actually going to impact on habitat would obviously have to be addressed at the reserve matter stage. And clearly, we do have planning conditions with regard to ecology that have been imposed as well.
Thank you. Councillor Guglielmi.
Oh, I hadn't finished, actually.
Oh, sorry, I beg your pardon.
So I'd like to let
your microphone off.
Chair, I'm more than happy to let Councillor...
No.
Well, it was actually to do with the timescale of the railway bridge, as there's been a lot of talk about it tonight. Do we have any idea of the timeline when this railway bridge would actually come into fruition?
Thank you, Chair. Well, there's a clear pressure on the applicant in that regard, because clearly they can't occupy more than 25 dwellings on the site without the delivery of the railway bridge and the diversion of the footpath. So clearly, if they don't meet that timescale, then development on the site would obviously have to be put on hold until it's resolved. 25 dwellings.
Over to you.
Right. Councillor, then I'll take... right, to you first. Oh, right.
Yes, thank you. I've got to admit, when I first looked at this application, it's been really concerning since the first 30 seconds that I looked at the map, is the land being dedicated to the site of a primary school. I'm currently reading through, and I'm just reassuring, and I'm a bit confused with this bit on page 13. The situation having a development in Kirby Cross is land in the outline application was put aside for a medical facility of some description. That now isn't happening because the Healthcare Association don't want it, and now the developer is trying to sell the land, put housing on it. So my concern is very, very similar with this one. Will Essex County Council require the school? So I'm just having a quick flick through. The school services based upon a development of the 208 houses, all being 2 bedrooms or more. The proposal would produce the need for 84, whatever, but it also goes in brackets. There are current places available in the area to meet the needs of early years and childcare. So is this school definitely going to happen, or is this going to be a case of the developers just putting it in there to sweeten the deal? That's what I'd like to know. Have Essex County Council actually turned around and said we are definitely going to use this land to build a primary school? That's what I'd like to know.
Thank you, Chair. In response to that, there is a executed Section 106 agreement that just needs formalised signing off. And there are clear commitments within that for the delivery of this land for a primary school, which will be delivered by the County Council. And there are triggers within them, not just on the developer in terms of the transfer of the land, but there's obviously commitments on the side of Essex County Council to take the delivery of that site as well for the delivery of the primary school. There's possibly a slight confusion here because it's twofold. One, we're obviously looking to offer land for a primary school on the site, but on top of that, in terms of the financial contributions, that is obviously for existing added children within primary schools and secondary school education, and it goes obviously on a cascade basis in terms of number of bedrooms, how many children are actually generated, and so the developer obviously committed to providing both the school on the site, but also contributions for new spaces within the schools as well, so it's twofold.
I'm sure, Councillor, you've looked at page 14 and seen what the financial contributions are. It's $1,283,000 for the primary education and $1,300,000 for the secondary school. Now, like you, I share the fears because we've seen it before where we've made contributions for doctor's surgeries. And then the NHS has suddenly said we don't want doctor surgery there. So I share your views that this is early stages. This is definitely outline only, and the final details we will get. But even to my basic maths, £2.5 million towards education is a massive sum, and I'm pretty certain they will be used well and truly. Yes, please do.
I have no doubt that the developer will honour their financial contributions there. But again, it is my just concern that yes, the developer has offered the land to the county council, but are the county council definitely going to take it to build a school? That is my deepest concern. I'm not quite sure if that. I might be a bit tired. I've got a lot going on, so I'm not quite too sure if that was answered. So that is all I want, is just a reassurance that if this goes ahead, that will be built.
Thank you, Chair. Well, I'll just really reiterate there are clear clauses within the Section 106 which has been signed by the applicant. It's also been signed by Essex County Council, and that includes obviously they are the education authority, and there are mechanisms not just for the applicant to transfer the land but for the county council to take that land and to deliver the school. And you're right, if they don't deliver it, then there are mechanisms to draw that back and claw that back by the developer, but clearly there are clauses within the agreement that school should be delivered and the land transferred to the county council to deliver it.
Do you want to come back on that, or are you happy with that?
If you don't mind, can I? So if Essex County Council turns around and says, OK, we'll take the land, hang on, we don't want to build it, the developer gets the land back.
Clearly, if the county council don't deliver the school on the site, they will have to meet the needs of the community. They can't take or shirk their responsibilities here. Clearly, there is 280 houses are actually going to be delivered on this site, and there is a need for child places in the primary school. So if they don't deliver it on this site, then they will have to meet the needs of the community elsewhere. But clearly, there's a Section 106 that they are signing up to, have signed up to actually deliver the school. So clearly that is the position, that the school will be delivered.
Yes, Councillor Alexander, sorry.
Picking up on my colleague's comments there, am I right in saying that, is it a 10-year gap plus this $2 million on top for Essex County Council to deliver a school on that particular site, or otherwise it would be returned back to the developer?
something I'm not sure of when they have to provide it, but we're just looking at that. Yes, any other questions while we're looking at that? We will come back to you on that one, Marsh. Any further questions from anybody? I know we've received requests actually to speak tonight, but procedure doesn't allow it, from the tendering parish council. They raised concerns on the traffic impact on Crow Lane and Crown Lane as a whole, and they were very worried that it appeared to them that highways had ignored them, their complaints. However, you will see that, and the officer touched on it, there are alterations to both top end and the bottom end of Crown Lane, hopefully, but both those two lanes are very narrow, but I've been down Crown Lane and found it very difficult to get onto the 133. Hope I've got the right name for the right lane. But County are there is quite a donation in the section 106 to alter the entrances. It doesn't alter the width, but it does alter the entrances to both those lanes. Right, have we got anywhere with... no, we've got nowhere on the...
Sorry, Chair, yes, we have looked at this issue now. On serving of the notice from the applicant to transfer the school land to the county council, they will then have 7 years to actually deliver the school. It's not to say, as I say, at the end of that 7-year period, if they haven't delivered the school, then clearly they have obligations to meet the needs of the new community. So if they don't provide the school on the site, then there will be an obligation on them to meet the needs of the child yield and population elsewhere within the local vicinity.
Right.
Well, in terms, I overheard a question in terms of the meantime, clearly there are other contributions that will be needed before the school is delivered. It's twofold. One is the delivery of the school on the site, but in addition to that, there is obviously it's 2.8 million contribution towards education and the increase in population in terms of child yield, which will deliver school places. So before the school is actually delivered, there will be a need to find spaces in other schools in the local area, and that is what that contribution is for.
Right. Further questions? Sorry, I can't take questions from the crowd. Further questions from the floor, please? No? Yes, Councillor.
Simply to sort of my personal curiosity, and I know curiosity killed the cat, have we got a timescale from the developer of how long these 200 and up to 280 dwellings would take to build?
I can't answer that question. There will be a need for a phasing of the application, and that is one of the conditions of the application, that they do provide a phasing plan for this particular development. My experience, having worked on both sides in terms of public sector and private, is most developments are built out at a rate of about 50 dwellings per annum. So you could have, say, a 4 or 5 year build out of this particular scheme. I suspect it'd be about 5 years.
Right, Councillor Alexander.
Chair, if I may, an interesting document has just been passed to me for a quick perusal. It is the attending District Council Planning Services and is the refusal and is dated 19th of November 2018. Am I right in thinking this is the same one? Something has been underlined. It goes on to say various things, local examination, inspector's conclusion, blah, 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 and given limited weight. In this case, the policies on the adopted local plan should prevail, and this application site is outside the settlement boundary of Weeley. Could we have some clarification on that? And it was signed by the head of planning. Thank you.
All right.
Chair, can I pass this to the Chair?
I'm just going to ask the...
Sorry, Councillor,
solicitor.
you're not permitted to have documents handed to only you. Well, you can hand it to me, but I'll have to look at it to see whether other members should have a copy of it.
Councillor Colthorpe.
Yeah, just to clarify, this is a document off the planning portal that we all have access to. It's for council's notice to the applicant in November when we originally declined, or refused rather, the application. So it's not a secret document. It's just something I happen to have in a set of papers in front of me. So. I've got loads of things here. What have we done now, Morris?
I'm off. Oh, that's you.
Thank you. Obviously, I needed to have a look at it first to see what the document was, because it was just handed to Councillor Alexander. It is a copy of the refusal notice for the previous application. So it was the notice, the decision notice that was issued on the refusal following November, 13th of November last year. And within the reasons for refusal, there is one sentence that's been underlined which says, in this case, the policies in the adopted local plan should prevail. And the application site is outside of the settlement development boundary for Weeley, and therefore contrary to policy QL1 in the council's adopted local plan, and a local location where the countryside policies apply, such as policy EN1 landscape character, which aims to protect and where possible enhance the district's landscape and distinctive local character. So that paragraph which was in the refusal notice from November refers to the landscaping reason for refusal, which was given in November.
Thank you, Chair. So I think the question was about the weight to be attributed to the adopted plan versus the emerging plan. And the reference was made to the decision notice that was produced in November of last year. Some things have changed since November last year, and one of them was some clarification in the MPPF that was published in February of this year. And that made it quite clear that the Council needed to use the standard method for calculating housing need. So in November of last year, the Council was still arguing that tendering had a special case in terms of its unattributable population change, and therefore 550 was the correct starting point for decisions. It sort of therefore argued that the housing policies, the settlement boundaries at that time could still be considered sort of up to date. The Council has had to accept since then because of the clarification to the MPPF, that it has to start when making development management decisions with the standard method, which is a much higher number. It can then ask to weigh into the balance the anomaly of the unattributable population change, but it's a material consideration from a different starting point. So I think we are in a different place to where we were in November, and that was partly what contributed to the sort of reappraisal of the situation. Clearly it is a little confusing because we have got an adopted plan and we have got an emerging plan, and we've seen through various appeal decisions over the last couple of years that different inspectors will attribute slightly different weight to different policies, whether they're emerging or saved policies, in different decisions.
Yes, Councillor.
Well, as I've not broken the Official Secrets Act, I shall plod on. Thank you for that very full explanation. So if I have this right, that was dated in 2018. But again, I refer back to page 5 of our agenda, 2.11, in which the development plan for tendering the 2007 adopted plan, paragraph 13 of the NPPF 2019. And then it goes on to say that paragraph 45 also allows weight to be given to the policies in the emerging plan. Am I right in saying that from your explanation, that was then and this is now?
Yes.
Well, in that particular respect, you're right. That's a quote from the up-to-date MPPF, and so, well, the almost up-to-date MPPF. And so, yes, you can still give weight, attribute weight to saved policies. I think the critical thing to weigh against that in this particular case is the site that you're considering this evening is an allocated site in the emerging local plan. It's the decision of the council, the full council, to include development on this site within its plan, within the emerging local plan, and the council made a decision as recently as last week to do that. And so that's a very clear statement of this council's intention for development of the sort before you this evening to take place within the plan period.
Yes, carry on. All right, Councillor Thorpe.
Yes, there's a couple of things in that document I no longer have in front of me, but it wasn't so much about housing supply that I was interested in. That that application refusal in November talked about the adopted plan and saved policies QL9, maintaining local character, and QL11, scale and nature of a development being appropriate to the locality. It then went on to talk about SAMU5, which is the allocation in the emerging local plan. It said something about that had yet to be examined, and we should therefore afford it limited weight. And it said something like, and I don't have it in front of me, weight should be further reduced due to the large number of public objections. Have any of those changed since November?
Quiet, please. Quiet, please. Right, Solicitor.
They were the reasons for refusal for the previous application, and reference has been made to legal advice that was given in relation to that application. The reason that it has not been referred to in any detail in relation to this application is, as you are aware, the Council has to consider this application afresh, as a brand new application. So in relation to those specific reasons for refusal, the council did receive advice that was advising the council that we did not have the evidence to defend those reasons for refusal. So in any appeal situation, irrespective of what the reasons for refusal are, the council has to provide to the inspector evidence to support those reasons for refusal. And that is where the council couldn't demonstrate that evidence. It wasn't available. The other thing is to bear in mind that the council's policy in relation to its local plan has to be taken into account and significant weight applied to it by this committee, as it is following the policy being set by full council. It is appreciated that the public have objected to the site allocation at Weeley. That process was part of formal consultation through the emerging local plan, and the council back in June 2017, I think it was, took into account the objections that were received through the public consultation when it was submitting its draft local plan, and made some amendments to allocations even within Weeley. So the public objection at that point was taken into account when the council made its decision at full councils. That's part of the democratic process. It is correct that the allocation of Weeley has not been looked at so far by the planning inspectorate as part of the local plan process. However, we have to make decisions as to where the evidence that's before the council at the moment, and there was no legal or planning justification to support those previous reasons for refusal.
Quiet, please. Councillor Alexander.
A little bit of waffle and then a question, if I may. I go back to page 2. I seem to like page 2 a lot. Let's have a see. 1.6. We go back to where we stand with the local plan, one that has come to the end of its time and one that's ensuing, and we are waiting for it to be adopted in its fullest form. The site lies outside of the settlement development boundary for Weeley, within the adopted local plan, but the emerging local plan is specifically allocated through policy SAMU5 for mixed residential development. Now, I have to say, do I like having to sit here, Chair, and do I like having to be the way I am right now? But this is not about me. This is about being a part of a committee that is here to discharge policies that are laid down within the ensuing local plan, to which the 2019 MPPF has stated that it must be given gravity. Right. Policy SAMU5, land south of Thorpe Road, Weeley, shows on the map, is allocated for mixed-use development as follows. At least 280 new homes of mixed size and type, including affordable housing as per the council's requirement. 1 hectare of land for employment hectare of land for public open space, 1 hectare of land for a new primary school with a co-located. You see, this is what it's going on about all the time. You see, this is under that D is under the section 106. But the proposals must accord with the following. The principal point of vehicle access will be off of Thorpe Road. Capacity or safety enhancement to the local highway network is necessary. Where necessary, enhancement of public transport, cycle, pedestrian infrastructure, and the provision of pedestrian and cycle bridge over the railway line as a replacement for the existing level crossing prior to the occupation. There are other parts to this, but it's all laid out in here. And although I wasn't here at that time that this was put together, I am here now. And I must carry out basically the policy because that's what this committee is about. I can't alter it. I can't rewrite it. I know that. I know that Lisa Hastings wouldn't tolerate that for one moment. So, with this, I would like to ask this question. If this was refused tonight, if it was refused, and this went before an inspector, what do you think, in your professional opinion, the outcome would be? Would it be refused or would it be allowed?
Thank you, Chairman. I think probably the first thing to say is if it were to be refused tonight, it would be considered by an inspector at an inquiry into refusal of planning permission. It wouldn't be considered by the local plan inspector who's examining the local plan, just for timescale reasons. So we've already, the inquiry into the refusal of planning permission would happen relatively quickly, whereas the examination into the local plan for this sort of policy is some way off yet. So I understand people's disappointment that this particular policy hasn't yet been examined in that forum, but practically that isn't going to happen. It will either, it would go to an inquiry about refusal of planning permission. Turning more specifically to your question, Councillor Alexander, this application is almost identical to the application that was previously submitted and refused. The advice that we had from when we took steps to defend the appeal that was lodged, the advice that we had from both legal advisors and from planners, including landscape specialists, was that the council didn't have evidence that would be able to support the reasons for refusal. I cannot think of anything that's changed significantly since that time that would alter that advice. And so I think that the council would be very unlikely to be able to successfully defend a refusal for the reasons that were given last time.
For the benefit of the good people of Weeley and others who have joined us here tonight, you mentioned 2 inspectors. Although I have a rudimentary knowledge of what you meant, could you explain what you meant by it would not go to a planning inspector, it would go to? Could you explain what those 2 inspectors would be?
Okay, so the council's local plan has been submitted to government for examination, and an inspector has been appointed to look at that local plan. It's been done in 2 sections, in 2 parts, and the first section is currently under examination, albeit the examination is kind of suspended at the moment. The policy that allocates this site is in section 2 of the local plan and won't be examined for some time yet. At least next year, it won't be this year. And so, that is some time away. There's a different process for looking at appeals against the refusal of planning permission or other issues relating to planning applications. So there's one inspector that looks at the local plan, and it would be a different inspector through a different process that would look at the appeal against the refusal of planning permission.
Am I right in saying by the choosing under SAMU 5 where we are now with this application in the area, at the time of the public consultation, and I had real difficulty in finding this. It's really like going through a minefield trying to find the questions you want, or the answers you're looking for. Am I right in saying that that this was heavily targeted and an alternative site was offered in Weeley at the time that this was actually in place? That also was heavily targeted, and this then was decided to be the policy that the working party at that time decided to go with.
Thank you, Chair. Okay, when the local plan goes through various stages, various iterations, and with consultations in between, other sites for development were promoted around Weeley, and there was a time when the council thought it would need to provide more housing land than is actually the case at the moment, and so more land was potentially going to be allocated in Weeley. That was actually scaled back considerably, and this site is the site that was actually eventually included within the version of the plan that was submitted to government. It did attract more objections from the public than other sites elsewhere in the district, but I think, as Lisa said earlier, the Planning Policy and Local Plan Committee and Council were aware of those issues that were raised and the number of objections when it was included, and the decision was made to submit the plan, including this site, for development to government for examination.
Sorry, the microphone was off. Ask the solicitor.
I just wanted to clarify something in relation to the question you asked before, and that was regarding reasons for refusal and would they be successful or not. It's very important to highlight that, as I hoped I'd made clear earlier, that the legal advice that was obtained was in relation to the reasons for refusal that the committee made in November 2018. So that legal advice is obviously related to those reasons for refusal. I just wanted to clarify that. I haven't heard anything from the committee this evening on alternative reasons for refusal, but I just wanted to make that point, that the advice was in relation to the previous decision in November last year.
Right. Councillor Stevenson.
Thank you, Chair. Just wanted to ask the Head of Planning to clarify something for me. Okay, so we've got two reasons for refusal. One's the house numbers and one's about the boundary and where it sits in the local plan and the emerging local plan. So we go to page 6, 2.13, halfway down it starts. Where emerging policies are particularly relevant to planning applications and can be given some weight in line with the principles set out in paragraph 48 of the MPPF, they will be considered and, where appropriate, referred to in the decision notices. In general terms, however, more weight can be given to policies in the MPPF and the adopted local plan. Now, my understanding of that is the adopted local plan is the one that was done in 2007. That doesn't have the boundary in it, and that one carries more weight. So that's point 1. When we come to the numbers, point 2, we go to 2.14. About 3/4 of the way down it starts, determining planning applications therefore entails weighing up the various material considerations. The housing land supply shortfall is relatively modest when calculated using the standard method prescribed by the MPPF. So in my assumptions, we are using the new way of working out the numbers. In addition, the actual need for housing was found to be much less than the figure produced by the standard method when tested at the recent examination in public of the local plan. Therefore, the justification for reducing weight attributed to local plan policies is reduced, as is the weight to be given to the delivery of new housing to help with the deficit. So by my reckoning, the weight of delivering new houses has been lowered, and also the weight to the emerging local plan. Bear in mind the emerging local plan. This is the second one I think we've had. We had one in 2013, and I'm sure at that time, with the councillors in front of that, we've been told the same advice, that the emerging local plan had some weight, and now that's completely scrapped and we're on a different version. I'm hearing a lot of talk about Section 2, but I think it's a bit of a red herring because we have to make a decision and Section 2 doesn't allow us to do that tonight. So I just wanted some clarification on which local plan or emerging local plan has the weight in this application, please.
My understanding, while the officers are going to reply, is we have the 2007 plan, which is the one we were working on, and we all appreciate is well out of date. But now we have the latest one, which, as Kath has explained, is in 2 sections, and the inspector is looking at the section 1. It will be February time when he looks at that one, but I don't know whether that Kath would comment on that.
Thank you, Chair. Okay, the adopted plan, the 2007 plan, clearly doesn't make sufficient provision for housing land up to 2033, going forward. Its time was expired in 2011. Although some policies are saved, it'd be very difficult to argue that that's true in terms of housing allocations, because it was only ever meant to provide housing land up to 2011. There's a whole new number of years of housing land supply needed up to 2033. Clearly, land needs to be allocated for housing. Some settlement boundaries need to be relaxed, if you like, or extended to allow that to happen. Where existing policies, so adopted policies, are in line with the MPPF, you can continue to give them more weight. But clearly, if you've got settlement boundaries drawn really tightly that wouldn't allow you to achieve the new housing numbers, you've got a sort of a conflict there with the MPPF. And in this particular case, the Council has decided that the way it wants to meet the new housing numbers looking forwards is to allocate land at various sites around the district, including this particular site. So it's sort of saying in order to comply with the requirements upon it to provide for housing land, it thinks it's appropriate for this site to be developed, along with other sites, and a number of which have been before this committee in the past and have been granted planning permission. So this isn't a unique situation. There have been other sites that are mentioned in the officer's report where this committee has granted planning permission for sites that are allocated in the emerging plan, in recognition that in order to achieve those housing numbers looking forwards, more land does need to be released.
Sorry, can I just add to that?
Yes. Ask the solicitor, then I'll go Councillor.
I think there's an additional point to make, is two actually. You made reference to the plan in 2013. That plan was never submitted to the planning inspectorate. So a lot of work was done on it, and early feedback from the inspector was that it was basically needed more work to be done before it was even submitted for consultation, submitted as part of the process. So that didn't actually achieve any sort of formal status, as it were. The other thing is, as well, as Kath's highlighted, that if your housing policy in your out-of-date plan is in conflict with MPPF, you cannot rely on it. So it's not one of those safe policies that you can rely on, and that's the sort of the main thrust of the MPPF. So I think it's QL1, So the housing policy in the 2007 would be out of date whilst we're in a position that we cannot defend a 5-year housing supply.
All right. Councillor Alexander, do you wish to come back? No. No? Councillor Thorpe?
Thank you. Over the last few years, where I've been on and off the planning committee, we always have this debate about the weight that's given to the old adopted local plan and the weight that's given to the emerging local plan. But there is a policy in the emerging local plan, SPL1, and I was just looking in Councillor Alexander's secret document, which is actually half of the local plan, so don't panic about that one. That says something that any development, it has 3 or 4 criteria, but it says a development has to be fair. What is the definition of fair, and how does it apply in this case? Is this fair?
Well,
anyone can answer that, really.
While we're looking for that one, I've got 2 waiting councillors, so I'll come back to guarantee you. Councillor Stevenson.
Okay, thank you for the answers from both the monitor officer and the head of planning surrounding the local plan. My concern is if, although it wasn't formally submitted, it wasn't formally submitted, the 2013 was turned down. There is no, unless somebody here wants to say it, guarantee that the current version of the local plan will pass the inspector's next test. And if that's the case, we are making a decision based on a version that may or may not pass. So I'm just curious. Just curious if I can get some advice on that, please.
I'll go first, and if I've missed anything, then I'm sure the head of planning will pick it up. When the council, and I'd use that as tendering district council, submits evidence to the inspector for its draft publication local plan, it is saying to the inspector, on the evidence that we have collated and submit in support of this plan, we, tendering district council, are saying to the inspector, we consider it to be sound. So I do appreciate what you're saying, that we haven't had that inspector's ratification that we've made the right decision, but as a council we are saying that that is our sound plan.
Councillor, are you happy with that? Yeah, I'll give you the chance.
Okay, so if that is the case, the whole reason the local plan is being held up at the moment is because of the North Essex garden communities. My understanding is that they're not really factored in at the moment to the local plan with reference to housing supply. If the local plan at stage 1 was to go through, then that would mean that the North Essex garden communities have gone through, and the need to open up other sites would not be required because we would have the North Essex garden communities. Have I got that right?
Perhaps that's what I want to go to Kath, yes.
The garden communities are included in the housing trajectory for the local plan, and the Planning Policy and Local Plan Committee discussed a report about the housing trajectory on the 16th of July, and it sets out the sort of up-to-date position in terms of housing delivery. And what it says is that overall the council obviously needs 11,000 homes if over the 20-year period, if 550 is found to be the correct number. Of those, 2,854 have been delivered already since 2013. And then there are large and small sites with around just under 7,000 homes granted planning permission. Then there are strategic sites in the emerging plan, such as this one, adding up to 1,370. There are smaller sites allocated, 249, and then there's an assumption that 1,250 will be delivered from the garden communities. That does produce a total of 12,479, so that's more than the 11,000, which is the minimum that's required. But obviously the good practice is to provide for a little bit of leeway with the numbers, because the one thing you can be certain of is that the nice, neat numbers and the assumptions that are made about each and every single site in the district that might come forward in the next 20 years won't be accurate. There will be some that will fall away, some might be delivered faster than have been assumed. But if the council were to make a decision to hit the nail on the head and actually only allocate sites or make assumptions about sites that are spot on the requirement, it's going to be really very vulnerable to appeals on sites that are completely contrary to the will of the council, to the emerging plan. And that's what's happened over the last couple of years, that lots of sites that have never been considered for allocation have come forward, and this committee have found themselves in a position of having to grant planning permission for some of them, or refusing and then losing those on appeal, because, if you like, we're so sort of close to the wire. So there's a deliberate decision, I think, it's been built in a little bit of flexibility to the plan. And so both the large allocations, smaller allocations and the garden communities are contained in the local plan that's been submitted to government, the plan that's been agreed by the council to be submitted to government.
Right. Yes. Please, Councillor.
Sorry, I think this is probably the last time I'll speak on it. It's good news that we've got 12,479. It does show that we have got more than we need.
Quiet, please.
You talk about what might happen in the future, other applications, everything else. That's not the job of this committee. The job of this committee is to examine the application in front of us tonight. And I think when you sit there and put flexibility and leeway as a reason to put 280 houses in Weeley, I'm finding that a bit difficult. I just don't see the justification based on that. I know things can go wrong. I don't think the appeal that's sitting in the wings has any bearing on this, as we've already been told. And I think just taking it on its face values, nothing seems to have changed. Your own advice seems to reinforce the reason for the failure of the last one. And I just can't see any reason. Yeah, thank you very much. Can you...
Okay, let's take a little breather. I'm just going through somewhat the summary of this development. As he says, we have to take this development on its merits. I've highlighted some areas of serious concern of mine. Another one of mine at the moment is the need for sort of social housing. And I've had a few emails recently concerning people who have been evicted for various reasons. People have been living in accommodation that is far too small for them. I'd just like to get some clarification on some numbers from this development. If it should go ahead, how much would the council be receiving for council housing? Please.
Thank you, Chairman. In that regard, it's fully in compliance with the local plan. They will be providing 30% as affordable units within this development, so they aren't looking for any reduction to what is actually being proposed in the local plan, so it will be 30% of the overall provision.
Yes, please come back.
Right, so by my mental arithmetic, which isn't always accurate, that's about 84 houses which should be affordable. How many of those will be council housing, though?
The general policy is 75% to 25% social to intermediate. Clearly, national guidance has moved the parameters with regard to what is now affordable housing, and there can be elements that can be low-cost housing, discounted market units that can form part of that definition as well. So clearly, in terms of the 30%, that's something our council officers will obviously have to negotiate as part of agreement on the scheme. But clearly it's 30% of the scheme, and that is fully compliant with our local plan and what we're looking to deliver here.
Councillor Clifton, you're still carrying? Yes.
Okay, yeah, just so I'm absolutely clear on that. So 30%, 84 houses of this development, should it go ahead, will be deemed affordable, of which the council will then get a negotiated amount of that at a later date.
I'm just looking at the provisions in the section 106 to see precisely what it says in that regard, so if I could come back to that.
Yes, Solicitor.
So if I read out the two definitions of affordable housing in the legal agreement and the affordable housing dwellings definition. Now these are standard provisions, and whilst I've got the mic, I'm just going to clarify actually what the legal agreement is. So because we have an appeal pending, part of that process is the planning inspectorate expects the parties to have negotiated a legal agreement in relation to the obligations as set out in the planning application, so that the planning inspectorate will consider that Section 106 agreement. So that is standard process and happens across the country. So the council had to negotiate an agreement. There was reference made earlier to the fact that county have signed it and the developer has signed it, and they have. We haven't signed it yet because I wanted to wait until the outcome of tonight's committee. If we don't sign it, then it would be put in by the developer as a unilateral undertaking in relation to the appeal process. So I just wanted to clarify that because we've made reference to this agreement quite a bit this evening. So affordable housing, as I say, it's quite standard definition, but it says housing provided to persons in housing need, whose needs are not met by the market with eligibility, determined with regards to local incomes and local house prices, with provision for the said housing to remain at an affordable price for future persons in housing need, and for any subsidy received to be recycled for alternative affordable housing provision, and includes affordable housing for rent and other tenures. Now, affordable housing dwellings are defined further, which says means 30% of the dwellings, which is the policy compliant, which shall, unless otherwise agreed by the council, comprise of 70% of that 30 is 70% affordable housing for rent and 30% other tenures, all provided in accordance with the affordable housing scheme.
Right. Councillor Alexander.
Thank you, Chair. I relate to what Councillor Stevenson was saying about the local plan, and for some time I think our head of planning will agree that I have been barrelling on about this and how it sits and how we're supposed to look at this. Much research over the last 3 days has shone great lights on this, and the whole thing is covered in this paragraph here, and it's simply this, that as from 2019 the MPPF allows weight to be given to policies in emerging plans according to that stage of preparation. It doesn't say adopted, because if they were adopted they wouldn't be emerging, they would be sound, and we would be looking at them as the policies would be taken forward. Now, from what I can understand is The fly in the ointment here is the fact that Section 1 does not involve just us, but it involves other players, Colchester, Braintree. And we were the ones who have led it now, and according to the chairman of the local plan committee today, we're at the top of the pile, and that should be looked at very soon. I don't think Section 2 of the local plan has ever been in dispute, or is there going to be any argument as to what it is, as it matches all the criteria, which I can understand in my own simple way. What's bothering me mainly, as I say, is that we don't quite understand. It appears to me that this word emerging, as I say, it is not adopted, it is emerging, and it is acceptable under the National Planning Policy Framework. Would you agree with that?
Yes, I think planners to agree. They are both nodding if one says yes or yes. That is their interpretation, but ask them to add on that.
Yeah, would it be okay if the officers answered that?
Yeah.
Well, that is the correct interpretation, yes. So, yes.
So that's clear.
It is.
Yeah. Councillor Cawthorne.
Thank you. Just to say something about Councillor Alexander's question, he's quite right in what he read out, but the preceding few words say the MPPF allows local planning authorities to give due weight to adopted, albeit outdated policies. So, I mean, it's true, but maybe it's not complete. But my real question was, did we manage to find a definition of emerging policy SPL1, and what do we think fair means in that policy?
Yes, please.
Thank you, Chairman. We did find emerging policy SPL1, but I'm not sure if we've got the right reference because it doesn't talk about being fair. Sorry.
Oh, sorry, what is the definition, please?
We're talking about SPL1, which is managing growth. Is that the one we're talking about?
That's right, yeah.
Yeah, I found that. And then did you say there's a reference to it elsewhere that talks about it being a fair policy?
Looking back at the refusal of the other application, it was mentioned in there, and there was a short definition of it, and so it had 3 or 4 things it mentioned, one of which was fair, but I don't have my document in front of me.
Yeah.
Thank you, Chair. I haven't found that reference yet, but policy SPL1 called Managing Growth actually just sets out the settlement hierarchy of the various settlements within the district, and Weeley is in there as a rural service centre. There's no other text in there. So whether the reference to fair is about, well, I better not guess. I don't know. I'd need to actually see it.
Okay, thank you for that. If I could get my document back, I'll have a rethink. Thank you.
Right. Right. No, I don't think we did answer that. You were looking for something on that, aren't you? Councillor Stevenson raised the point just now. You're satisfied with
thanks,
that,
Chair.
are you? Okay. Right.
Are you going to give Kathy the opportunity to...
Yes, please.
Chairman, I just wondered if it would be helpful to say a little bit more about Councillor Stevenson's question about flexibility and whether or not it's needed within the local plan allocation. Just a couple of things. One of them is that actually we're already into the plan period of the emerging plan, so it started in 2013-14, so we're 6 years into it now. And over that period, we've actually undersupplied against what's required by 2,854 dwellings. So that's just an example that it's not just a kind of theoretical thing to build in some additional supply. It's a very real issue that the district has faced. And sort of in any case, the decision to build in that bit of flexibility is one that was made by the committee and the council submitting the plan. So it's sort of the policy that comes out of that decision that this committee needs to take into account rather than changing the policy that's been made.
Oscar.
Thank you for that. So we've undersupplied certain years, but I think the last 2.5 years we've oversupplied, haven't we? I think that's true to the case. And when you say undersupplies, which figure are you going against, 550 or 864? Thank you.
Yeah, Councillor Steve, you're absolutely right. It's been a varied picture, but overall, in total, over the last 6 years, we've undersupplied by 2,854 against 550 a year.
Yeah. And what would you set as a trend? Figures 3 years ago or figures today?
The district has definitely supplied an increasing number over the past few years. There have been, and I'm no doubt there will be in the future, lots of arguments and public inquiries about why that is. Some people might say that's because there was a sort of suppressed demand for a few years, that it was very low and then it jumped up, but only time will tell. But I think I really just want to make the point that I think it is a real risk, undersupply, and that the trajectory isn't an accurate thing. And the policy decision, if you like, has already been made elsewhere.
Thank you. It's duly noted.
Right, councillors. Councillors on my left have been very quiet for the last 5 minutes. Can I see if there's any further points? I haven't got anybody left on my list now. Yes, Councillor Cawthron.
Thank you. Yes, I've clarified my question on policy SPL1. You're quite right. It's where settlement hierarchies are defined, and Weeley is a rural service centre. But a commentary was made by the author of the refusal of the other planning application, and it says SPL1 of the emerging local plan, where housing development is envisaged to be at a level that is fair, achievable and sustainable. That was the observation made in November. Does that still apply?
Thank you, Chair. Yes, that is some sort of commentary around the emerging policy, but that emerging policy is in the emerging plan that allocates the 280 on this site. So the fair, achievable and sustainable, I think, is describing what's contained sort of within the plan, what's envisaged for the various settlements.
Right, that's... Can I ask for further questions? No? Then is anybody prepared now to pass the resolution? Councillor Alexander.
Thank you, Chair. I've listened intently to the debate. Again, I have to put it to everyone in this room that we are here to serve tendering district council at the planning committee and not allow our own personal feelings to be a part of the decision. Although I do have grave reservations. I can't read, Chair, the people's minds of my fellow councillors. I don't know what they're thinking. But I'm going to make a proposal. And my proposal will be that we accept approval as laid out and allow my colleagues to come back with any amendments that they want. So approval, I go.
I had a proposer. Do I have a seconder for that, please? I have a seconder for it. Now, we've got a proposer and a second. We'll have debate. And as...
Can I just add something to mine?
Yes, as the seconder wishes to add.
I would like to add, if I may, Chairman, if we go through this, and if I could ask officers, there's been considerable conversation about the bridge and bats and the surveys. Is it possible, please, that there could be some negotiation around a more desirable design in the countryside with Network Rail, if it were possible, if that could be put in? And also, could the surveys be readdressed, ready for when it comes back as detail? If that could be something that could be considered, I'd appreciate it, and I don't know if Councillor Alexander would accept that.
Accepted.
All right. And yes, Councillor.
Thank you, Chairman. The other thing I would be concerned about with regard to the application, if it was to be approved tonight, would be if the detailed application was not to come back to this committee, because I would like to see it come back. Thank you, Chairman.
Yes, this is outlined, and so if it were approved, then obviously the full detailed application would come back to us on the type and shape of houses and all sorts of other things, if that was your wish. Yes, Councillor
Clifton.
Clifton, thank you.
Yeah, this application, normally when I look at planning on a town council level, which I've been for 4 years, I look at things that add to the community and make things better. There's a lot of things in here from experience that I've seen that I don't like the look of. Presumably this land to be gifted to the county council, and then they've got 7 years to build a school. I really have severe reservations about that. I don't have a lot of confidence that will happen. That's how I personally feel. However, at my age in life, despite appearances, I am one of those generations nowadays that struggle to get onto the property ladder, and that is because there is a shortage of houses to buy. And that also rides in my mind that houses have got to be built somewhere. And although for the generation of today, that might not be appropriate, I do take into consideration the generations of the future, and where people like myself will live, where particularly my children will possibly live, and they've got to live somewhere. And I have to admit that's something I'm taking into consideration tonight as we've had this debate. There's been a lot of criticism of this development, but it's a lot of criticism that I believe that could be addressed during a more detailed and full application phase.
Thank you very much.
Good points.
Any further points before I put the proposal to you? No further points? Right, then I'm going to ask you to vote on the recommendation on page 3 plus the conditions on page 38, starting at para 8.1, together with the point just raised by my Vice Chairman, so that you know what you're voting on. Is that understood by everybody? It is. Right. Those in favour of the recommendation as put by the officers on page 3 plus the conditions on page 38 plus the additional, please show you are in favour. 1, 2, 3, 4, 5, 6. That's 6. And those against? 2, 3. 3. Thank you. So that outline permission
Chairman,
is
could I have my objections noted in the minutes, please?
Yes, indeed.
Thank you.
I'm quite happy to record the three.
Could my vote be recorded as well, please?
Yeah, okay. Right. Okay. Sorry. I think we will. Yes, we'll have a break.
Except you two aren't voting.
Right, colleagues, we'll make a start now. We're back onto agenda item 4, and as you appreciate, there are, or certainly in my case, I wasn't here for the site visit, so in line with the Constitution, I can't sit on this particular one, and so I'm going to hand over to my Vice Chairman. We ought to elect a Vice Chairman, I'm told, in this case, because...
I keep doing it, but...
Right. Do I have a nomination? I do. Councillor Fowler. That's good. That Councillor McWilliams acts for this particular item. Right. Now, the next thing is, I wasn't the only person who didn't go on the site visit, so only those on the site visit can attend, in which case that does leave 5 of you, but, or not but, it's 5 of you, and that is within the Constitution for you to still deliberate on the item. So at that point, I shall leave, and the people who can vote, I think, are Councillor Alexander, Councillor Colthron, Councillor Fowler, yes, Councillor Codling, and me, the chairman. Right.
Okay.
Just. It wasn't actually voted for you to be chair, so I'm just going to ask members to record.
Okay, that's brilliant. I'd much rather that be done.
Councillors, can I, although Councillor Fowler moved, I think, Councillor McWilliams to be Vice Chairman, I don't think it was seconded or voted upon. So, thank you. Seconded. Can you vote, please? Show your thank you.
Thank you. Right. Quite simple, this one, councillors. Agenda item 4. And it was deferred, but I'm going to put it straight over to our officers now to actually give us all the detail. Thank you.
Thank you, Chair. Thank you, Chair. As the Chair rightly said, the application was deferred at the last meeting on the 30th of July, and that was for further information with regard to overhead power lines. Since the deferment, the applicant has come back to us and has confirmed that the overhead power lines will be undergrounded in consultation with UK Power Networks. And accordingly, in terms of the recommendation, there is now an additional planning condition recommended, and I'll read that out to you. And it says, prior to the commencement of any above-ground works, full details of the route of the underground power line shall be submitted to and approved in writing by the local planning authority. Development shall be carried out in accordance with the approved details. Otherwise, the recommendation stays as the previous recommendation, which was for approval.
Thank you. Have we any comments to make? Anybody, any questions to ask over this one? No? Well, can I see any movement to approval or disapproval? Yes, Councillor Fowler. Councillor Fowler.
Thank you, Chair. I'm pleased actually that these power lines are going underground, because I live in an area where there are numerous overhead power lines and the numerous problems that go along with overhead power cables and telephone cables, of course. So I'm quite pleased about that, so I would be happy to support this application now. Thank you, Chairman.
Anyone? Councillor Corton?
I'm happy to second that.
So that's been proposed and that has been seconded. Can I see those who are all in favour? That is unanimous. Right. Thank you, councillors, and I think that draws us to a close for this meeting for the evening. Thank you very much.